Hello everyone, welcome to LaExcellence IAS, and today in episode 3 of CID, which is Current Issues of the Day program, we are going to have a comprehensive discussion with respect to the debate over simultaneous elections, which is seen over various newspapers and various news headings. Simultaneous elections can be called even as one nation, one election concept, which is majorly talked about, wherein the elections in the union level and elections in the state level or assemblies, whatever we call, can be done simultaneously together, so that, as said by the government, in order to reduce the expenditure what we are incurring over the elections in various stages, what we do for union government and for the state legislative assemblies. On the other end, apart from expenditure, the second explanation which is given with respect to simultaneous elections is the governance period which is getting wasted because of various elections. Because whenever there are state legislative assembly elections of various states, and again Lok Sabha elections which are conducted at the union level, so during this, in the 5 years course of time, the various elections at the state level and union level becomes a point of period where governance is getting affected. So government states that these are the two major reasons wherein we find that the country should go for one nation, one election concept, or simultaneous elections for the union and the state is what is being proposed. So today's discussion will be hovering around four major questions. That is, if in order to have simultaneous elections in the country, do we require, number one, constitutional amendment? So in order to conduct simultaneous elections in the country, do we require constitutional amendment? And number two, the discussion we will be talking about will be what are the various procedures, with respect to amendment of constitution, with respect to amendment of constitution. And number three, we will talk about can constitutional amendment struck down by Supreme Court. So whenever a constitutional amendment is brought in, if it is in violation of basic structure of the constitution, can it be struck down by the Supreme Court? And as we say, there is ratification of states which is required, because whenever there is changes made in the federal structure of the constitution, so we say that ratification of the states is necessary. So can this ratification of states be avoided? So without a ratification of states, can we bring in the required amendments in the constitution to conduct simultaneous elections in the country? So these are the four questions which we will be discussing in detail with respect to the debate or discussion whatever we are going to have with respect to simultaneous election. So why we are talking this topic today? As you all know, on September 2nd, Union government constituted an 8-member committee under the leadership of late ex-president Sri Ramnath Kovind. So under the leadership of Ramnath Kovind, who was ex-president of India, this 8-member committee was formed in order to understand the feasibility of simultaneous elections in the country. So the committee has been entrusted with various provisions under which it has to make studies, and let the government know on what all provisions we will be, or under what all conditions we will be able to conduct simultaneous elections in the country. So there were few provisions or points which were given in order to be understood or read by the committee and propose the changes to the government. Among them, one of the provisions includes about the ratification of the changes by the states. Is it necessary? So that is where we will be talking about the amendments required in the constitution and about the ratification of the states. So whenever there are changes to be made in the constitution, usually we talk about Article 368. Article 368 makes provisions with respect to amendment of the constitution. Here we find there are three types of changes. Number one, the amendments that can be made in the constitution by simple majority. However, those changes which are made using this simple majority concept are not considered as an amendment under Article 368. Very important statement, remember this. So any changes or any amendment which are brought in the Constitution of India by using simple majority are not considered as an amendment under Article 368. So under Article 368 we find the second provision which can be used in order to making amendments in the Constitution are special majority, and special majority includes, or if we are saying something needs to be amended under special majority, then it means it requires 2/3 members present and voting support, which should include half of total membership of state or half of total membership of the house. So these two conditions should be satisfied in order to bring an amendment if it is constitutional, that is special majority. And third change or third amendment is talked with respect to special majority plus ratification by half of states. So if there are any changes or if there is any amendment which affects the federal structure of the constitution, then half of the states ratification is necessary. So the third point what we discussed with respect to the provisions under which the committee is expected to make study about the feasibility of simultaneous elections in this country, then is there a requirement of ratification of states is the question. So this is what the committee has to study about and get back with the recommendations to the government. So let us see. Number one, as we discussed, the first provision was with respect to simple majority. And if we talk about what are all the provisions which we can amend with simple majority. So simple majority means half of present and voting. Present and voting. So here whatever membership we have got with respect to, or members we have got with respect to Lok Sabha and Rajya Sabha. Suppose 545 seats in Lok Sabha and 245 seats in Rajya Sabha. So half of the present, not the total membership. So half of the present and voting. Suppose out of 545 members in Lok Sabha, there are only 520 people who are attending and they are present for voting. Then half of 520 will be 260. So any bill which is trying to bring in changes which can be done with simple majority should get 261 votes in Lok Sabha on that day. And we are saying that 545 members are present who are voting on that day. And in that case, if 261 members are voting to a particular amendment or change, that will be considered as passed. And here, if we are taking for an example about what are the provisions which will be considered under this, we are talking about Article 4. Article 4 under Indian Constitution talks about changes related to reorganization of states. Changes related to reorganization of states. In the same way, Article 169 talks about creation or abolition of legislative councils of state. So, Article 169, under Article 169, if you want to create a legislative council for a particular state, then you can create it by just simple majority. So, these are the examples which we take for the changes which can be done with just simple majority. That is half of the members present and voting, not the total membership of the house. So, very clearly understand this concept. In the same way, if we are talking about ratification of the states, so now we are saying for which of the amendments do we need ratification of states? As I told, any provision which has federal structure or any amendment which is going to affect the federal structure of the constitution will have to be considered wherein that amendment has to get ratification of states. Under Article 368, there are various provisions which are being listed which require special majority. So, under Article 368 subclause 2, we find there are various provisions which are listed which requires special majority in order to be passed in the parliament. Like suppose if there is change in methodology of elections of president. So, if there is any change with respect to methodology of elections or provisions regarding the elections of provisions regarding election of the president, that is under Article 54 and 55. In the same way, if there are any change in the extent of executive power of union, if there is any change in the extent of executive power of union, under Article 72 is also, or sorry, 73 is states, 73 is union. In the same way, if there is any change in the executive power of states under Article 163. So, if there are any changes which are being made under Article 162 or under Article 73, then it requires special majority or these provisions will require amendment under Article 368. In the same way, if there are any changes made with respect to union judiciary or high court, so if there are any changes or if there are any changes in the provisions regarding Supreme Court or High Court jurisdiction, these will be considered under it. So, if there are any changes in Article 368 itself, will also be considered as a provision which requires ratification of states. So, all these provisions are provisions which affect the federal structure of the country or which affect the federal structure which we have established under the constitution. and these require ratification by half of the states. And for these provisions, we call, or these provisions are also called as entrenched provisions. These provisions are also called as entrenched provisions. These are commonly called as entrenched provisions. So here, if we look at under Article 368 subclause 2, we find that there are various provisions under which if there are any changes made, then we require ratification of states. In 2018, there was a law commission which was established in order to study the feasibility of simultaneous elections. However, the law commission reported that in Indian context, simultaneous elections is not feasible. And if we are making any changes, then obviously there are constitutional amendments which we have to bring in. Like suppose, as per law commission report, it was not feasible. And this law commission was constituted under the chairmanship of Justice B.S. Chauhan. Remember this? This can be used when you are writing any answers. So Justice B.S. Chauhan in 2018 recommended that simultaneous elections are not feasible in Indian context. And if you look at Article 172, which stipulates that every state legislature will be functional for a period of 5 years from the date of its constitution. So from the date of its constitution, every state legislature will be active for the period of 5 years. And now, at any point of time, if you see, there are various tenures for every state which are different as per its constitution. And if we are trying to bring in simultaneous elections in this country, automatically you have to dissolve some of the states before its expiry. And if any government has to expire here, there are two provisions. That is, number one, the state has to voluntarily dissolve its house so that new elections will be conducted. There is a provision wherein states can voluntarily give up, or else there has to be a constitutional machinery breakdown. Constitutional machinery breakdown wherein president's rule can be brought in and president can take over the government so that new elections can be conducted. And if you look at these two provisions, voluntary dissolution is not possible in the states where the governments are in opposition in the center. Like suppose in Karnataka, Congress is in power, whereas in central we have BJP in power. Obviously, Karnataka elections have recently held in the month of May, and after 6 months you are asking the government to expire its term and go for new elections, that it is not possible and states will not definitely accept it. And here Article 172 needs to be changed if simultaneous elections has to be implemented in Indian context. And with respect to simultaneous elections, there were debates in the Constituent Assembly also. And whenever there are any provisions which requires ratification of states and a question is asked whether it is necessary, for that we can remember an answer given by Dr. B.R. Ambedkar, the chairman of drafting commission or drafting committee of the constitution. So Dr. B.R. Ambedkar said, if we are not going to consider the words of the states or ratification of the states is felt to be unnecessary, then automatically what we are trying to bring down is the federal structure of the constitution, and we are trying to negate the separation of powers, which is very much essential in order to build a proper democratic setup in any country. So ratification of states is necessary for that matter in all the provisions, but however we find that in some provisions at least, that is under article 368 subclause 2, where various provisions have been clearly defined as we discussed in the previous section, that ratification of states is necessary in order to continue or in order to take over some of the changes or amendments in the constitution. So in that case, here we have to understand that if we have to bring in simultaneous elections in this country, there are few necessary constitutional amendments which have to be brought in. And if those amendments have to be brought in under article 368 subclause 2, which are also commonly called as entrenched provisions, then automatically ratification of states is necessary. And if we are talking about ratification of states, and once this constitutional amendment has been brought in, so can it be declared void or null by the judiciary is the next question. So if this has to be taken into consideration, then here we have to remember two important judgments. One is Kyoto-Holland versus Zakilu 1992. Famously, this case is called as Kyoto-Holland case. In this Kyoto-Holland case 1992, which is also very famously called as anti-defection law. And you also know that anti-defection law was brought in order to reduce horse trading, which was very famously among the political parties with respect to the formation of government. So in order to bring down that horse trading activity, anti-defection law brought in or introduced 10th schedule in the Indian constitution. So when this 10th schedule or anti-defection law, which is also called as, or if you are asked what was the constitutional amendment, that was 52nd Constitutional Amendment Act. So 52nd Constitutional Amendment Act introduced 10th schedule in the Indian constitution, and this 10th schedule, as you all know, is related to anti-defection law. So when this anti-defection law was brought in, there was a provision or para 7 in this law which actually affected the state government, or the provision with respect to the working of the state governments, wherein Supreme Court held that para 7 is invalid or null or void with respect to the basic structure of the Indian constitution, and apart from this para 7, other provisions will be in operation. So here it was held that when para 7 was against the federal structure of the Indian constitution, then automatically para 7 was removed from the 52nd Constitutional Amendment Act and made sure the other provisions were in operation. In the same way, there was another case in 2021 which was Union of India versus Rajendra N. Shah, which was also called as 97th Amendment Act 2011. If you all remember, 97th Amendment Act 2011 was majorly related to cooperative societies, and Rajendra Shah versus Union of India case 2021 was with respect to the cooperative societies. And if you look at 7th schedule, which we talk about distribution of powers between union, state and concurrent list, what we see, wherein cooperative societies come under exclusive authority of the state. However, by this 97th Constitutional Amendment Act, central government was trying to interfere in the state's jurisdiction. In this Rajendra Shah versus Union of India case 2021, the Supreme Court applied doctrine of severability. Doctrine of severability. Wherein, what is doctrine of severability? Suppose in any law there are n provisions 1, 2, 3, 4, and if the judiciary feels one of the provision of the law is not in accordance with the provisions of the constitution, then such a provision can be removed and various other provisions can be kept operational. So this is called concept of doctrine of severability. In the same way, under this 97th Constitutional Amendment Act, the cooperative society provisions which were interfering with the state government's powers were removed and only multi-state cooperative societies provisions were kept active. So multi-state cooperative societies provisions were kept active. And if at all, under simultaneous elections wherein constitutional amendment is required, and if the government is trying to do without ratification of half of the states, then definitely there is going to be a question in the judiciary about the validity of the law. And even if once the states, that is half of the states, because getting half of the states ratification is easier because not all the states were taken into consideration. So once half of the states are ratified, automatically the bill goes for the assent of President of India. Then the question lies, once states give its ratification, can it take it back? So there is one US judgment which is taken into consideration, because till now such a scenario has not been encountered wherein states have taken back the ratification. So there was one famous case in United States which was related to Chandler versus Wise. Under this Chandler versus Wise United States judiciary case, wherein states did not have an option of rescinding, that is going back from its call or giving its ratification. So once it is ratified, it is ratified. It cannot be taken back. So this we have taken inference from United States judiciary. However, in Indian scenario, such a question has not yet arrived, but over a period of time we will have to see or look for any of these scenarios. So here, under the discussion of simultaneous elections being implemented in the country, there are various questions which needs to be understood and addressed. However, with time, with the progress what government will be trying to make, we will be discussing about further updates and further discussions with respect to one nation, one election concept. So I hope today's discussion was able to clear your doubts with respect to simultaneous elections in this country. We'll come up with various other topics and various issues which we will discuss in detail in order to help you understand the issues better for your preparation of this examination. So till the next episode, we'll see you again. Take care of your health and studies. Jai Hind, Jai Karnataka.